Part 4. Children detained or brought before a court. 63. It shall be conclusively presumed that no child under the age of 12 years can be guilty of an offense. 64. 1. Where a person, whether charged with an offense or not, is brought before any court otherwise than for the purpose of giving evidence, and it appears to the court that the person is a child, the court shall a. Make due inquiry as to the age of that person, and b. For that purpose, shall take such evidence as may be forthcoming at the hearing of the case. 2. An order or judgment of the court shall not be invalidated by any subsequent proof that the person's age has not been correctly stated to the court, and the age presumed or declared by the court to be the age of the person so brought before it shall, for the purposes of this Act, be deemed to be the true age of that person. 3. Where it appears to the court that the person so brought before it has attained the age of 18 years, that person shall, for the purposes of this Act, be deemed to be an adult. 4. Where, in any charge or indictment for any offence under this Act or any of the offences mentioned in the second schedule, except offences specified in subsection 5. A. It is alleged that the person by or in respect of whom the offence was committed was a child or was under or had attained any specified age, and b. The person appears to the court to have been, at the date of the commission of the alleged offence, a child or to have been under, or to have attained the specified age, as the case may be. The person shall for the purposes of this Act be presumed at that date to have been a child or to have been under or to have attained that age, as the case may be, unless the contrary is proved. 5. The offences referred to in subsection 4 are offences against the following sections of the Offences Against the Person Act, section 45. Procuring defilement of girl under 18, 48. Carnally knowing girl under 12, 50, carnally knowing girl above 12 and under 16. 51, inducing or encouraging defilement of girl on premises, 57, abduction of girl under 16, 58, procurement. 60, abduction with intent to have carnal knowledge, 61, unlawful detention with intent to have carnal knowledge, or 69, child stealing. 65, every court, in dealing with a child who is brought before it either as being in need of care or protection or as an offender, or otherwise, shall have regard to the best interests of the child and shall, if it deems it necessary, take steps for removing the child from undesirable surroundings and for securing that proper provision is made for the child's education and training. 66. Arrangements shall be made for preventing a child who is a. At a police station in connection with the commission of any offence, whether committed by the child or by any other person. b. Being conveyed to or from any criminal court remand centre or place of safety, or c. Waiting before or after attendance in any court. From associating with any adult, not being a relative, who is charged with any offence other than an offence with which the child is jointly charged. 67. 1. Where a person who is apparently a child is apprehended, with or without warrant, and cannot be brought forthwith before a court, the officer or sub-officer of police in charge of the police station to which the person is brought shall act in accordance with subsection 2. 2. The officer or sub-officer shall a. So inform the government agency responsible for the care and protection of children, and b. Inquire into the case and may, in accordance with the Bail Act, release the person on a recognizance being entered into by the person or his parent or guardian, with or without sureties, for such amount as will, in the opinion of the officer or sub-officer, secure the person's attendance upon the hearing of the charge, and shall so release that person unless I. The charge is one of murder or other grave crime, or 2. It is necessary in the person's interest to remove the person from association with any reputed criminal or prostitute, or 3. The officer or sub-officer has reason to believe that the person's release would defeat the ends of justice. 3. Where a person apparently a child is apprehended and is not released under subsection 2, the agency responsible for the care and protection of children shall cause the person to be detained in a juvenile remand center until the person can be brought before a court. 68. 1. Any court on remanding or committing for trial a child who is not released on bail shall commit that child to custody in a juvenile remand center named in the commitment, to be detained there for the period for which the child is remanded or until the child is there delivered in due course of law, provided that in the case of a child who has attained the age of 14 years, a. The court shall not be obliged so to commit that child if the court certifies that the child is of I. So unruly a character that the child cannot safely be so committed, or 2. So depraved a character that the child is not a fit person to be so detained, and b. Where the court so certifies, the child may be committed to such place, including an adult correctional center, as may be specified in the commitment warrant. 2. Subject to subsection 3, the court which makes an order under subsection I, committing a child to custody may, on application, a. Vary the order, or b. Revoke the order in respect of a child referred to in the proviso to subsection 1. 3. If an application under subsection 2 cannot conveniently be made to the court which made the order for commitment, action under that subsection may be taken by any court having jurisdiction in the place where the sitting of the court which made the order was held. 3. If an application under subsection 2 cannot conveniently be made to the court which made the order for commitment, action under that subsection may be taken by any court having jurisdiction in the place where the sitting of the court which made the order was held. 4. If the order is revoked, the child may be committed to such place, including an adult correctional center, as may be specified in the commitment warrant. 69. 1. When a child is charged with any offense or is for any other reason brought before a court, the child's parent or guardian may, in any case, and shall, if such parent or guardian can be found and resides within a reasonable distance, be required to attend at the court before which the case is heard or determined, during all the stages of the proceedings, unless the court is satisfied that it would be unreasonable to require his attendance. 2. Where a child is arrested or taken to a juvenile remand center, the officer or sub-officer of police in charge of the police station in the district of the court before which the child will appear shall cause the parent or guardian of that child, if he can be found, to be warned to attend court. 3. For the purpose of enforcing the attendance of a parent or guardian, and enabling him to take part in the proceedings and enabling orders to be made against him, a summons may be issued and served on him requiring attendance before the court, and the provisions of the Justices of the Peace Jurisdiction Act shall, with the necessary adaptations and modifications, apply to the procedure on such summons. 4. The parent or guardian whose attendance is required under this section shall be the parent or guardian having the actual possession and control of the child, provided that the attendance of such parent shall not be required if the child is, prior to the institution of the proceedings, removed from the parent's custody or charge by an order of a court. 70. 1. Where a child is to be brought before a. Any court charged with an offense. b. A children's court as being in need of care and protection. The person bringing the child before the court shall cause notice of the grounds on which the child is brought before the court, and of the date on which such matter will be heard, to be served in accordance with subsection 2. 2. The notice referred to in subsection 1. Shall be served within a reasonable time before such date. A. On a children's officer, if the child is to be brought before the court as being in need of care and protection. B. In any other case, on the probation and aftercare officer, if any, of the district, and C. On the children's advocate. So, however, that no such notice shall be necessary whenever a children's officer, the probation and aftercare officer or the children's advocate, as the case may be, is the person bringing the child before the court. 3. Upon the receipt of the notice referred to in subsection I, it shall be the duty of the probation and aftercare officer on whom it is served to make such investigations and render available to the court such information as to the child's home surroundings, school record, health and character, as the probation and aftercare officer is able to obtain and as, in his opinion, is likely to be of assistance to the court. (71) 1. The minister responsible for justice shall cause to be established courts, to be known as children's courts, which shall be constituted in accordance with the provisions of the third schedule and, when so constituted and sitting for the purpose of exercising any jurisdiction conferred on them by this or any other enactment, shall be deemed to have, subject to the provisions of this Act, all the powers of a resident magistrate's court, and the procedure in the children's court, subject to the provisions of this Act, shall be the same as in the resident magistrate's court. 2. The Governor-General may appoint, in respect of each children's court, a clerk and deputy clerk who shall, in respect of the children's court to which they are so appointed, have all powers and perform all duties which the clerk and deputy clerk have and perform in respect of a resident magistrate's court, provided that it shall be lawful for any clerk and deputy clerk, respectively, assigned under Section 7 of the Judicature, Family Court, Act, to exercise the like powers and perform the like duties as aforesaid in respect of the children's court constituted by virtue of paragraph 4 of the third schedule. 3. Without prejudice to the power to bring before a children's court by any other means, any child in need of care or protection, the attendance of a child, or of any other person before a children's court in accordance with the provisions of this Act may be enforced by the same officers. The same process and in the same way as the attendance of persons before justices of the peace may be enforced under the provisions of the Justices of the Peace Jurisdiction Act. 4. Children's court shall sit as often as may be necessary for the purpose of exercising any jurisdiction conferred on them by or under this or any other enactment. 5. Subject to subsection 6, a children's court shall sit in such place or places as may from time to time be specified under paragraph 3 of the third schedule as the place or places in which such court shall sit. 6. Where no place is so specified, the children's court shall sit either in a different building or room from that in which sittings of courts other than children's courts are held, or on different days or at different times from those on which sittings of such other courts are held. 7. No person shall be present at any sitting of a children's court except a. Members and officers of the court, and any authorized person as defined in Section 13. b. Parties to the case before the court, their attorneys at law, and witnesses giving or having given their evidence, and other persons directly concerned with the case. c. Bona fide representatives of newspapers or news agencies. d. Such other persons as the court may specially authorize to be present. 8. Where a child is brought before a children's court, it shall be the duty of such court to explain to the child in as simple language as possible a. The reason for the child being before the court, and b. That the child is entitled to the assistance of the children's advocate. 9. Where a child is charged before a children's court with any offense and does not have legal representation, the court shall act in accordance with Section 4, 3 10. Where a child is charged with any offense and admits the offense, or the court is satisfied that the offense has been proved, the court shall record a finding to that effect and, before sentencing the child, shall obtain such information as to the child's general conduct, home surroundings, school record, and medical history, as may enable it to deal with the case in the best interests of the child. 11. For the purpose of obtaining the information referred to in subsection 10, or for special observation, the court may from time to time remand the child on bail or in custody. 12. An appeal shall lie from any decision of a children's court in the same manner and subject to the same procedure as an appeal from a resident magistrate's court. 72. 1. Subject to the provisions of this section, no charge against a child and no application in relation to a child in need of care or protection shall be heard by any court of summary jurisdiction which is not a children's court. 2. Subject to subsection 3, a charge made jointly against a child and a person who has attained the age of 18 years shall not be heard by a children's court. 3. Where, in the course of any proceedings before a children's court, it appears that a person so jointly charged has attained the age of 18 years. A. Nothing in subsection 2 shall be construed as preventing the children's court, if it thinks fit, from proceeding with the hearing and determination of those proceedings, and b. Where it does so, it shall be deemed to have, in relation to the person who has attained the age of 18 years, all the powers of a court of summary jurisdiction. 4. Where a child is charged with an offense, the charge may be heard by a court of summary jurisdiction which is not a children's court if a person who has attained the age of 18 years is charged at the same time with aiding, abetting, causing, procuring, allowing or permitting the offense. 5. Where, in the course of any proceedings before any court of summary jurisdiction other than a children's court, it appears that the person to whom the proceedings relate is a child, nothing in this section shall be construed as preventing that court, if it thinks fit, from proceeding with the hearing and determination of those proceedings. 6. Where a child a. who has not attained the age of 14 years is charged with any offense, or b. who has attained the age of 14 years is charged with any offense other than an offense specified in the 4th schedule. The charge shall, subject to any right of appeal provided by this or any other enactment, finally be disposed of by a children's court, or if the charge is heard before a court of summary jurisdiction that is not a children's court, by that court of summary jurisdiction, without prejudice, however, to the provisions of section 75. 7. Where a child who has attained the age of 14 years is charged with an offense specified in the 4th schedule. A. Proceedings for the child's committal for trial shall, subject to subsection I, be heard in a children's court, and b. if, on the termination of those proceedings, the court is satisfied that the child should be committed for trial, the court shall so commit the child and shall bind such child and the witnesses, by recognizance to appear at the court to which such child is committed. 8. No direction, whether contained in this or in any other enactment, that a charge shall be brought before a children's court shall be construed as restricting the powers of any resident magistrate or justice of the peace to entertain an application for bail or for a remand and to hear such evidence as may be necessary for that purpose. 73. 1. A children's court sitting for the purpose of hearing a charge against, or an application relating to, a person who is believed to be a child may, if it thinks fit, proceed with the hearing and determination of the charge or application, notwithstanding that it is discovered that the person in question is not a child. 2. Where a children's court has remanded a child for information to be obtained with respect to that child or for special observation. Any children's court sitting in the same parish or place. A. May in the child's absence extend the period of remand, so, however, that the child appears before a court at least once in every 7 days. B. When the required information has been obtained, may, subject to any right of appeal provided by this Act, deal with the matter finally. 3. Where the court by which a child was originally remanded has recorded a finding that the child is guilty of an offence charged, it shall not be necessary for any court which subsequently deals with that child under this section to hear evidence as to the commission of that offence, except in so far as may be considered that such evidence will assist the court in determining the manner in which the child should be dealt with. 74. Where under the provisions of this Act, a child is tried before any court which is not a children's court, then such court shall, in relation to that child, have all the powers of a children's court. 75. 1. Any court by or before which a child is found guilty of an offence other than murder may, if it thinks fit, remit the case to a children's court acting for the place where the offender was committed for trial, or, if he was not committed for trial, to a children's court acting either for the same place as the remitting court or for the place in which the offender resides. 2. Where any such case is so remitted, the offender shall be brought before a children's court accordingly, and that court may deal with him in any way in which it might have dealt with him if he had been tried and found guilty by that court. 3. No appeal shall lie against an order of remission made under subsection I, but nothing in this subsection shall affect any right of appeal against a verdict or finding on which such an order is founded, and a person aggrieved by the order of the children's court to which the case is remitted may appeal therefrom, as if he had been tried by and had pleaded guilty before the children's court. 4. A court that makes an order remitting a case to a children's court under this section A. May give such directions as appear to be necessary with respect to the custody of the offender or for his release on bail until he can be brought before the children's court, and B. Shall cause to be transmitted to the clerk of the children's court, a certificate I. Setting out the nature of the offence. 2. Stating that the offender has been found guilty thereof, and that the case has been remitted for the purpose of being dealt with under this section. 76. 1. Where a child has been found guilty of any offence before a children's court, that court may, subject to the provisions of this Act, make an order A. Dismissing the case. B. For probation under the Probation of Offenders Act. C. Placing the child, either in addition to or without making any other order under this section for a specified period not exceeding 3 years, under the supervision of a probation and aftercare officer or some other person to be selected for the purpose by the minister. D. Committing the child to the care of any fit person, whether a relative or not, who is willing to undertake the care of the child. E. In accordance with subsection 7, if the child's parent or guardian consents to the making of the order. F. Sending the child to a juvenile correctional center. G. Ordering the parent or guardian of the child to pay a fine, damages or costs.